According to the schedule, we would have a full panel for the second part, but I think we're going to have to skip this because there's not enough time for these two parts in this session. And because we have such a distinguished guest, Mr. Gurdial Singh, who was the prosecutor and who is still the prosecutor of the Kuala Lumpur War Crimes Tribunals, and the Kuala Lumpur War Crimes Tribunal is in fact the continuation, but on a much higher level, of the World Tribunal on Iraq. I remember in 2007 I have presented the findings of the World Tribunal to the War Crimes Commission that was then established under the guidance of Dr. Mahathir. I'm not going to bother you any further, but I will give the floor to Mr. Gurdial Singh, and he will explain everything about the War Crimes Tribunal proceedings in Kuala Lumpur.
Thank you very much, Dirk, and very good evening to all our friends. I'm so glad that my good friend Nilofer preceded my presentation, because she has put in more eloquent language than I myself could muster the precise position of the role of people's tribunals. The Kuala Lumpur War Crimes Tribunal is a people's tribunal. And the key question is, what is the role of a people's tribunal which, on the face of it, has no enforceability in international? It's incapable of enforcing its actions through the normal processes of intergovernmental action. So that is the point. Now, Nilofer has made it very clear that there has been a very distinct rollback of the natural process of criminalizing war, where in one country, if there is a murder, this is like the Pistorius trial that some of you may be conversant with, that is going on in South Africa, where there is so much emphasis on the fact that one person has killed another person, and this has to be adjudicated in full transparent manner throughout the world, because it is a heinous crime. And yet, despite the fact that there is a UN Charter, despite the fact that there are very clear provisions which illegalizes war, and there has been, after the Second World War, the judgment at Nuremberg, which has made it very clear that waging a war without the process that has been established is the supreme crime that exists, we find that this has no resonance in international law as it is being implemented in this day. In other words, as Nilofer has expressed so clearly, there has been a rollback of the legal system. There has been a rollback of international law. The exception seems to have become the norm. The natural processes have been undermined so substantially. And that is why the role of the People's Tribunal takes on an entire dimension of its own. It is, as has been presented, the whole Gandhian concept, because what is important, what is to be recognized, is that the people, history has shown, the people and the people alone are the motive force in the making of world history. It is the people ultimately who determine the direction. Gandhi showed it with his march for salt, with his passive resistance, that the whole course of the British Empire was transformed by a man who Winston Churchill described as a naked fakir coming to the parliamentary buildings to try to subvert the British Empire, and yet he did. And so this is the point that is being made, that the ultimate, the state itself, the normal forces do not have the monopoly of adjudicating upon what is right, what is wrong, what is moral, what is not moral, what is natural, and what is exceptional. It is the people. And this is the context in which the tribunals, like the KL War Crimes Tribunals, are there to reassert, to reclaim the lost space, to reverse the reversal of the judgment at Nuremberg, to restore the basic principles that links man with common humanity, that links man with common morality. That is the link. And that is why these crimes have been created. The only justification, and it has universal jurisdiction, the only justification for this is that these crimes are so abhorrent, that they are so much against the order of nature that they cannot be accepted. And that is why these crimes are attributed with the dimension of being treated as universal jurisdiction, which means that there is no need for you to establish that the crime was committed within your state. There is no need to establish that the person was a citizen in your country. The only link is the link to humanity, which grants the universal jurisdiction. Of course, we have no illusion about the fact that there is, as is now, no enforceable powers. That is why, as has been said before today, the key question then is we, of course, take advantage of existing avenues that present themselves to advance, to reclaim the lost space of international law, to reassert the credibility, to reassert the power of international law. And law, therefore, becomes a very critical, one of the very critical, not the only, but one of the very critical tools to reassert and reclaim the lost space, the rollback of the Nuremberg principles. So we have no illusions about the fact that we can achieve all this through proceeding via the International Criminal Court or trying to get special tribunals set up. There is no illusion about that, but they do make some advances. And these advances then can be built upon in a whole panoply of various actions that are taken by citizens to complement, to supplement the legal process itself. Now, speaking specific, like the Wall case and so on, that has been referred to. Speaking specifically of the KL War Crimes Tribunal, it is there for a variety of purposes. It is there for citizens to reclaim space, especially when their avenues have been closed. We have had 3 trials. The last trial, for example, we have 3 trials, and these trials have involved the evidence that is presented by witnesses who have been actually involved in those, have been the victims of those crimes of aggression. So, in a sense, therefore, it is to also restore, specifically the KL War Crimes Tribunal is there to reassert the accountability of those who should be made accountable. It is to delegitimize those who seek to legitimize their actions through various sophisticated sophistry of legal arguments. It is also to bring about a closure for victims, because they have had no presentation in a formal structure that replicates, for example, the International Criminal Court of their victim status. It is also to bring about an awareness amongst the citizenry, an educative process that is an educative process for people to understand what exactly went on, where it went on, what are the valid claims that can be made, what are the claims that should be rejected, what is the truth ultimately. So ultimately, the KL War Crimes Tribunal is part of this preparatory process that has been initiated along with all other citizens' initiatives throughout the world to set in motion this whole process to reclaim lost space and to restore the credibility of the law of nations based on one link, the link to humanity amongst the peoples of the world. In this context, therefore, if you look at the next, so the The tribunal itself was set up under the foundation, Pradana Foundation, and we have the backing of a Prime Minister, former Prime Minister Tun Mahathir. We heard his message this morning, who is very, very committed, very passionate, and who has, in a large extent, very creditable standing amongst a large number of third world countries. And this becomes very, very important for us. It is a formally established entity. Next. The important thing is the second bullet point, establish two key institutions, is the Kuala Lumpur War Crimes Commission. This commission hears the Chief Prosecutor present all of the evidence. This is like a finding, a prima facie finding, a filtering process, the first step. It then determines there is a hearing. We have war crimes commissioners. They are from a variety of very respectable and eminent people. We've had the advantage of having two people who were UN officers present in, who were formally appointed by the United Nations to look after the sanctions process and so on, and who resigned because they found the whole process so inequitable, so dastardly, that on point of principle they resigned. One is Hans Sponek and the other one is Dennis Halliday. So we had these commissioners. They go through, we present the evidence over 3, 4, 5 days. It's very complete evidence that is presented. People come forward as witnesses, and then the evidence is evaluated. And on the basis of that, the War Crimes Commission then makes a recommendation as to what is their understanding of the process and what are the kind of crimes that they feel have been committed. All right, and then they make a recommendation. They make a recommendation to the legal team. The legal team has a large number of lawyers. I happen to head the legal team as the chief prosecutor. Then we formulate charges. The charges are formulated in very complete form, very thorough, very full of particulars as to each allegation. And then there is the KL War Crimes Tribunal. We have a panel of judges. There's a moving panel of judges consisting of international and as well as domestic eminent persons, largely retired judges or people who have a very intimate knowledge of international law and have considerable standing. Now, then the war crimes, then the case is heard and a decision is made. And as I said, next, we have had in 2011, we had crimes against peace against George Bush and Tony Blair, which resulted in a guilty verdict. And then the following year, next, we had war crimes, torture, crimes against humanity, against Bush, Rumsfeld, Cheney, Gonzalez, Bush, Rumsfeld, and Cheney. And very interestingly also, we had against their legal advisors. That was a tough case to break because, you know, there is a large number of impediments to suing people who give advice on instruction to their bosses, as it were. And we had this against Eddington, Haynes, Bybee, and John Yu, principally who are legal advisors to the three gentlemen. And it ended up in a guilty verdict on 11th of May 2012. Now, this is a critical part. I said before that the whole point about this is that this is a preparatory work. This is work in progress. This is work that is designed to achieve a purpose, to attain an objective, to bring war criminals to justice, to bring proper closure to victims of war. So the war crimes, the Kuala Lumpur War Crimes Tribunal, with this long-term objective in mind, has set about having a process which will have acceptability and credibility amongst the rest of the world. And as a result of that, we assess ourselves on these criteria. First is there must be fairness of process. We have a charter, we have our rules of evidence. The rules of evidence and the rules of procedure are modeled on the International Criminal Court, with some improvements, in fact, to make it even more abundantly fair. And these rules are adhered to very, very very carefully. Now, for example, we formulate a charge. The charge, when formulated, must have particulars, sufficient particulars to inform the accused exactly of what is the crime committed, when it was committed, where it was committed, how it was committed. So we condescend to a large amount of particulars. And then the charge is served. We have provisions. If it is ex-head of state, we can serve it on the embassy. For example, Bush, we serve it on the American embassy, and they accept it. They don't reject it. They probably did not know what the charge, what it was about. They must have thought it's a normal document with the Malaysian government congratulating them on something or other. So they accepted, they accepted the charge quite happily. And for the rest, we then get the charges served at the last known address of the individuals concerned. We do a search. We get a lot of assistance. It's not easy. But we do manage to get, for example, we know John Yu is in the university at one of the prestigious, I think, Berkeley University in California. So we get people to serve these documents on them. And then, as we expect, there is no counsel for them. So we have a large number of lawyers. For example, defending George Bush and Tony Blair, we had 7 lawyers, all international lawyers, or international PhD students, for example, assisting as amicus curiae, as friends of the court. And they fight these cases very vigorously. For example, in the case of George Bush, the trial, we even had to have, they even raised a preliminary objection, which then had to be adjudicated, which was that there is immunity against these kind of prosecutions for heads of state, not only under general principles, but also because of certain decrees, if you like, that were passed in the United States by George Bush, exempting themselves from this kind of obligations, legal obligations. So we have this setup is, in terms of rules of procedure, in terms of natural justice, is very complete. As you know, International Criminal Court, you can also, under the ICC, if I'm not mistaken, you can also try people in absentia. You can also try people who refuse to participate as such, although they have been they are remanded and they are brought to the court and so on. And then we also have right of parties. Maybe there are others who are not directly indicted, but who may have some concern over the fact that they would be in the process implicated. Then we also have procedures for those people to be represented. As far as professionalism is concerned, adjudicators, prosecutors, defense, we are very careful in choosing those people who are able to present evidence and collect documents, collect the documentation in as professional a manner as possible. So that has been maintained. The first trial was headed by a very senior judge of the highest court in Malaysia itself, who is a very well-respected person, at least in the context of Asian countries. And then as far as legalism is concerned, we spend a lot of time researching the questions, each of those questions that is to be presented. And the most important is the quality of the evidence, right? For example, in the first trial, we had to try to get the Freedom of Information Act. Under the Freedom of Information Act, information from the United States. We had to go and get the original, or from the original websites, or from authenticated secondary sources. For example, the Downing minutes, the entire correspondence. We got hold of the Attorney General's opinion that was given. We got hold of the changes. We got hold of opinion that was given by very respected lawyers in the UK I think they were commissioned by the WWF or some such organization to look into the criminality of the war with all those opinions. So we paid very close regard to the quality of evidence that we were going to present. I think Dirk was there, and so many others here were there as well. So we paid very, very careful regard to the kind of evidence. And we had the benefit, because by that time, these people, these war criminals, they were gloating over their life successes. So they wrote their autobiographies. So we had the autobiography of George Bush, where he talked about his role and so on and so forth. We had the autobiography of Blair, his book, The Journey, where he explains at great length. We had other secondary sources. We had other sources. We had Gray, who was the ambassador at that time, UK ambassador to the US, and he had a lot of intimate information about the kind of conversations that went on between Bush and Blair. So we had a whole collection, very careful collection of all this evidence to present. As far as the other victims were concerned, who came to give the evidence, for example, we had prisoners from Bagram, we had prisoners from Guantanamo, we had prisoners from Abu Ghraib, who came and testified as to the actual conditions that were obtained. And these people were subject to cross-examination. Some of them did not want to be identified. This was challenged. And they had to do it under circumstances which drew a balance between protecting their confidentiality as well as allowing the amicus curiae to cross-examine them. So this was, in our view, one of the most interesting and most fortifying, if you like, aspects of this trial, because of the fact that we were very careful in ensuring that only the kind of evidence that would be entirely acceptable and by the highest level of adjudication would be presented. And indeed, not all of the evidence was accepted, although bulk of it was accepted because of the way in which it was collected. Each person who came to testify also had to make a statutory declaration, which is a declaration which is protected in law. If you falsify any facet, any aspect of that evidence, you are liable, at least under Malaysian law, to criminal prosecution and to imprisonment. So only those who are prepared to come and stake their commitment to the truth, as it were, in the form of a statutory declaration, were the ones who were accepted to give testimony. We had one last year, another trial, which was against the state of Israel for genocide. And this is very interesting, because it was in respect. Most genocides are after the event has happened. But this is a continuing event. And we traced it historically from pre-1948, the whole process up to now. With regard to the first trial against Bush and Blair, also we traced it to times beyond, where you talked about the document, about the New Century document, right? Project for the New American Century. We traced it to that and to comments that is made. There's a very interesting book that is written by Bob Woodward, for example, where he traced this whole, traced the whole planning of the war, or the desire to begin to capture the world, as it were, to present the to assert the hegemony, very much before even the document of project for the New American Century came up. And that came up in the Foreign Affairs publication, which is the official kind of recognized publication. It's not something that is secret. But of course, it was done at a time when those people like Wolfowitz and so on and so forth were not in power. These neocons only came into power much later, and then began to enact their plan, the project, after 9/11. Okay, and then of course transparency. We had complete transparency as to the process. I think for the first trial, there was a lot of publicity given even by the Washington Post, by publication, by newspapers in India, in Japan, and of course in the ASEAN region. It was very well covered and as well by the social media. And as to, for example, as to the first process, the first trial, next, we have, this is Richard Falk, Professor Emeritus of International Law at Princeton and UN Rapporteur on Palestine, just to quote from a commentary he gave of that trial, where he said the KL War Crimes Tribunal followed a juridical procedure purported to operate in a legally responsible manner. This would endow its finding and recommendations with a legal weight expected to extend beyond a moral condemnation of the defendant. So this, at least there has been an acknowledgement that the way in which we are proceeding is along the lines that we had projected for ourselves. And this is very important because, next slide, very important for us, because we want this to be part of this entire process, right, which begins to show that there is no safe haven for war criminals. Maybe today there is, maybe yesterday there is, maybe in a year or two times there is safety in a haven that has been created by the powers that be, but that there cannot forever be a safe haven. Now, one of the critical points is the name and shame. Just the fact that there is a tribunal that is held under these kind of conditions, and there is publicity in relation to these conditions, there is, 2 minutes, yes, there is a name and shame. Now, name and shame, naming the person and shaming the person, is actually a sanction and international law. In a large number of international treaties that I participate in negotiating, this is one of the clear sanctions that drawn up. So even though it comes from a source that emanates from a people's tribunal, the fact of name and shame being canvassed, being publicized, is actually an acknowledged form of formal sanction itself. So that's very critical. And then, of course, we want to provide as complete a record as possible. After that, we publish the whole proceedings, entire proceedings, together with a judgment in books like this, which we then present to libraries so that it will begin to form the corpus of jurisprudence in relation to war crimes. And many respectable libraries, or libraries of quite key law schools, have accepted this, and we hope that this will be cited as a basis. And we also, which we are going to discuss tomorrow, what next? And what next will be universal jurisdiction, getting countries to begin to initiate actions so that the space for war crimes for war criminals is critically curtailed. And this provides a very complete record that we can present, and we are actually beginning to liaise with people like Gazan, for example, to see where this matter can go. But that will be a matter for discussion. Now, I conclude by saying what is critical is the other factor of creating public awareness, because if not in our lifetime, at least, or if not in the immediate future, at least in the future, when even law school, when law students, we heard a testimony today, when law students can take this up and use it as a basis to begin to indict war criminals for the kind of heinous crimes that they have committed. I thank you very much.
Unfortunately, we have to close now, so there is no time for questions, only for Sabah. Sabah has one question. I think we leave the question of what to do next and what were the lessons that we learned today. We have to skip this, and we think we have to take this up tomorrow if there is more time. But in any case, we will keep on cooperating with everyone who is here in the building and everyone that we have cooperated with the past 11 years to advance the struggle for justice. It's yours, Sabah.
Doug, thank you for giving me the opportunity to raise one single issue. Mr. Singh, I've seen the books, I've seen the work which is done by the Kuala Lumpur, I've seen the work which was done by Brussels Tribunal, I've seen the work by others. The most sophisticated, the most technically sound documents I've seen are the Kuala Lumpur ones. The question is this: we have such a wealth of material which is really capable of being put to a court of law. Are there any plans of doing that? Now, perhaps it could be discussed later and tomorrow, but I would have hoped that somehow this can actually go into the judiciary as opposed to the People's Court.
I think we can discuss that tomorrow, because there's a whole set of possible actions that we can do based on this very complete record of findings. And I've given a PowerPoint presentation which I don't know, you can distribute or something in soft copies. We also wrote to the International Criminal Court, of course, after the finding against Bush and Blair. They replied in a very convoluted, very nice diplomatic way to say no. But when they said no, they also said, why don't you try blah, blah, blah. So we're trying to kind of snooker them, if you like, by saying, okay, we're going to go by your brilliant advice, but are you prepared to assume jurisdiction where even your advice does not work along the lines that you have proposed? So the International Criminal Court will not move, and so this will, I think we can discuss that tomorrow as to how exactly we can try to build on this kind of a tribunal work to advance the whole cause.
Thank you, Mr. Singh, for being with us. We think it was very important that you were here. We expected a whole delegation, but the health of Tun Mahathir, who was expected to be here, is not so good. As you may have seen on the video, he has been fitter. But Mr. Singh here is a very particular guest, because the Kuala Lumpur until now has produced the best judicial documents that can serve for the future, and I think we can keep on cooperating in this.
We also have produced a CD of all the trials and all the proceedings, so those who wish to have it, I think we'll make it available to you, Dirk, and then you can deal with it.